Hello and welcome to the Race and Rights Podcast. This is Sahar Aziz, Distinguished Professor at Rutgers Law School and author of the book The Racial Muslim: When Racism Crushes Religious Freedom. I'm also the Executive Director of the Rutgers Law School Center for Security, Race, and Rights. You can follow me on social media at Sahar Aziz Law and learn more about my work at saharazizlaw.com. The Center for Security, Race, and Rights, also known as CSRR, engages in research, education, and advocacy on law and policy that adversely impact the civil and human rights of America's diverse Muslim, Arab, and South Asian communities. We do so through an interfaith, cross-racial, and interdisciplinary approach. To learn more about CSRR's work, visit our website, csrr.rutgers.edu, and follow us on social media at Rutgers CSRR and at RUCSRR. And if you find the Race and Rights Podcast informative, please consider making a tax-deductible donation by going to our website, csrr.rutgers.edu, and press the donate button. And please give generously. In today's episode, I am in conversation with voting rights legal scholar, Professor Atiba Ellis, about the voting rights paradox. Professor Ellis posits that a central paradox has plagued and continues to plague the American right to vote. That is, the American Republic has always conditioned participation in the democratic process on an anti-democratic ideology of worthiness needed to exercise the rights of citizenship. This reality has shaped debates around the right to vote in the past and in the present, and has made it more difficult for the law to embrace the rhetoric of a universal right to vote. That is, a right for all citizens to participate freely and fairly. This is the defining dilemma of voting rights in American history. Indeed, as Professor Ellis explains, the history surrounding voting rights admit to the progress that was required to gain a more expansive right to vote for all Americans, yet at the same time recognize that these rights are inherently and constantly contested. The continued contest around voting rights is ultimately attributable to this paradox. As such, Professor Ellis provides the historical, legal, and political backdrop against which the Voting Rights Act of 1965 has been transformed from a powerful tool for affirmatively ending racial discrimination, especially against African American voters, to an ineffective safeguard against rising disenfranchisement of racial minorities today. Let's hear what our guest has to say about a topic that will shape the hotly contested November 2026 midterm elections.
Professor Aziz, it's a pleasure to be on the podcast with you. For those of you who don't know, we basically came up along the same line at the same time. So it's been fun being co-contributors, and now we get to collaborate a little.
Yes, it is. It is.
So thanks for
we've seen a lot in our academic careers.
We have indeed. That could be its own podcast. But you want to talk about redistricting? And because, redistricting kind of is one of these ongoing lightning rods around our political culture, and it comes up time and again. To put it simply, the problem with redistricting is that politicians ultimately get to choose their electorate rather than the electorate choosing the politicians it wants to represent them. And here's what I mean by that. It is a requirement under federal law in the United States that electoral districts get redrawn at least every decade when there is a new census. The idea all the way back to the original Constitution was that we want political districts to represent who's actually there. And certainly, we count the whole number of persons within the country, within each state, and then we draw electoral districts all the way from congressional districts and federal elections to local city council seats or county commission seats. And the idea, ever since a bunch of cases in the early 1960s, Baker v. Carr, Reynolds v. Sims, the idea is that the Equal Protection Clause of the Constitution requires these districts to be the same size. And there's some that, when it comes to state and local districts, the 14th Amendment mandates that these districts be roughly the same. The idea being, if each district for, let's say, a state legislature is the same size as practical, then it will take the same number of votes in any given district to elect an equivalent office. So if you have 100 districts in each district, no matter which district you live in, your vote is worth the same thing. Now, the Equal Protection Clause covers state elections. The Article 1 of the Constitution, which, among other things, talks about how people get elected to Congress, covers federal elections. In that sense, right, each congressional district has to be the same size as any other congressional district, with the one exception being, and actually, let me back up a second. So basically, every 10 years, the federal government takes the census, and we figure out how many people there are in the country. We divide that number by 435 congressional seats, and that product becomes the number by which each congressional seat in most states, that's the size that it has to reflect. There's some variance depending on state to state. Obviously, a state like California, the biggest, has at this point nearly 60 congressional seats. I don't know the exact number off the top of my head, but then you look at the smallest state in the union, which I believe is Wyoming, right? That number, I think Wyoming has somewhere, around 500,000 people. But if you divide up the 350 million people in the United States by 435, that's more than 500,000 people. So Wyoming and the other small states are guaranteed one representative. So here is the thing. This becomes an issue generally, whether you're looking at a city council, a state legislature, the US Congress. Within each unit, you can draw maps to figure out what the district could look like, right? And objectively, you could just simply draw a map and just make them all equal sized. And in this era of the technology and the data tracking that it takes to know where people live, and AI, which just animates the process exponentially, you can very easily draw maps that reflect who the people are, how they tend to vote, right? People forget that, like, your party affiliation, a lot of your personal information related to your voting is public record. The only thing that's actually secret in a secret ballot is who you actually voted for. But the fact that I'm Atiba Ellis and what party I registered for can be looked up easily. And so you can register and you can figure out where Democrats live, where Republicans live, where people of higher income live, lower income. You can pool all this data into a database and draw districts across an area, across a state, let's say, in a variety of ways, right? And in some senses, this is the process. Now, the problem is you can draw those districts to favor, redistricting would be redistricting if we just simply hit a button and told the AI to draw a map that was just, we have to elect 100 seats, create 100 districts, and not care who's there. But the trick is the politicians really do care. They care a great deal. And so, and
right.
a lot of
and let me
stuff
just
feeds into that.
Yeah, let me just ask you, because I think I want to make sure that our audience understands why they care. Well, I think your point about politicians caring about how districts are drawn is intuitive. And we've seen these battles over and over again, especially whenever the census comes out. But as a voting rights legal expert, can you explain what are the criteria that are permitted or prohibited in the politicians' kind of bipartisan attempts to draw districts to their advantage? And I'll ask you within the context of the contemporary moment in terms of efforts on the part of both parties, right, to engage in mid-decade redistricting, which is unusual because it's not during the census years, in the run-up to the 2026 elections. Right. Is this unusual? What is driving the effort? And again, how does that impact the permissible or prohibited criteria under the law in redistricting?
So as a general matter, right, when it comes to redistricting, the tradition is that we look at this every 10 years, right? The rule has tended to be we get new numbers about who lives where, and then we draw districts around that. Now, how the districts get drawn, we look at a number of factors. Politicians, first and foremost, you want a compact district, right? If where the same group of people in the same area are kind of living closely together, and we want to draw a relatively regular line around that. If it's like a long snake-looking thing where you connect people across various cities or counties, that's discouraged, right? So this sort of compactness, keeping communities of interest, like I said, living in the same city or the same county, keeping those sorts of groups together. Traditional sorts of things also include other communities of interest, the people who might live in like the valley might differ from the people on the mountaintop about something. And it's all very local, and you kind of figure it out. And probably the most interested thing for politicians is things like incumbency protection, right? And maintaining a sort of political balance, right? To foreshadow the conversation we're thinking about, like with the Louisiana versus Calais section, Louisiana is where the Speaker of the House is from, right? And so maintaining his seat is a very big interest vote, both for Louisiana and for, the Speaker and for the Republican Party across the country, for example. So maintaining those sorts of interests. But you also have to take into account the other side. And a lot of the litigation about redistricting has historically been about how do you treat the other side? If you're the Republicans in Louisiana, or if you're the Democrats in Massachusetts, how do you draw the district and take into account the other side? The law used to say that there could be a theory around partisan gerrymandering. And so gerrymandering, just to define our terms, is the idea that you draw misshapen districts that are designed to advantage one group over another. The two types of groups we've tended to worry about are partisan groups, political parties. So in one sense, it's sort of like, can the majority party basically draw districts that at least theoretically keep the minority party out of power, right? When we're talking about Republicans versus Democrats. And, the Supreme Court for a while toyed with the idea that there would be a remedy for that under the Constitution. In a series of cases from like the 80s to 2019, there was at least a plurality that would recognize some kind of theory, but never a majority. But then in 2019, in a case called Ruccio versus Common Cause, in a solid majority, Chief Justice John Roberts says there is no judicially manageable theory by which the federal courts could provide remedies for partisan gerrymandering under the Constitution, and therefore the federal courts cannot hear these cases. The Constitution being, giving limited powers to the federal courts, that there was no remedy under the Equal Protection Clause that the courts could administer in a fair way that doesn't impose cost on the powers of the, legislative branch or the executive branch to decide what the shapes of the districts should be, right? So it, in essence, is kind of like saying, this is a question for politicians, not a question for the courts. And in an odd way, and those of you who are the fans of the redistricting jurisprudence of the courts, this is a long arc from a case from the 40s called Colgrove versus Green, where Justice Frankfurter, I think, said that the court shouldn't venture into the political thicket, right? They shouldn't get involved in these questions. But like I said earlier, in cases like Reynolds v. Sims, which articulate this one person, one vote principle, right? Everyone's vote should weigh the same. That becomes a constant. But then we think, well, then it's unfair for the party in power to draw districts that keep itself in power and exclude the minority party. But for federal law, the Supreme Court rejected that in Ruccio. 2 points. One, it's fair to say, though, that each state may or may not have a constitutional provision in its state constitution to deal with redistricting. I teach at Case Western Reserve University in Cleveland, Ohio. Ohio has a provision like that in the Constitution that makes redistricting decisions first and foremost in the hands of a commission. And if the commission can't make a decision, then the legislature addresses it. Other states have other structures where they remove it, and other states have anti-gerrymandering provisions in them, which elicit fights on the state level. But the federal courts since 2019 have no dog in this fight. But then there's the other level. The other gerrymandering problem that we have is racial gerrymandering. And there are two approaches to this. One has usually been around the Voting Rights Act of 1965. So when the Voting Rights Act was passed, it was intended to stop the discriminatory practices against racial minorities in the United States when it comes to elections. In that context, we were talking about African Americans in the South who were excluded by a variety of means from exercising political power. Over time, and given the breadth of Section 2 of the Act, which basically rearticulates the concept of the 15th Amendment, no discrimination on the basis of race in voting, by specifically targeting any practice or device that would make it less likely for minorities to be able to participate in the political process. That's what Section 2 does. There are a couple of details that we can flesh out, but the idea is that any device, any law, right, that has the result of diminishing the ability of minority in a political community, a racial minority in a political community, from being able to participate is subject to Section 2. And if it's discriminatory, it can be adjudicated as such. So the idea, which came up in this case called Thornburg v. Jingles from the mid-'80s, was that a court could look and see a map that gets drawn that's alleged to discriminate against minority groups. And they could compare that to a theoretical map where that minority group would have a majority. And then they could look at if that group was politically cohesive, right? Do they basically vote mostly for the same people at the same time and have the same political interest? And the third question under the Jingles test is, has the racial majority undercut that political minority routinely and regularly. If those facts can be established, then the court can look at the totality of the circumstance and figure out whether that map is likely the product of discriminatory animus or not. And if it is, it gets struck down and the federal courts can insert a new map in its place. The other theory is called, this Jingles test is about racial vote dilution. The other theory is racial gerrymandering. Two completely different things, even though they are almost sound alike. But the premise of them is very different. So this racial gerrymandering theory, or often referred to as a Shaw theory, from a case called Shaw v. Reno from the mid-90s, is in essence the idea that race cannot so predominate drawing a map that it, in essence, is the number one reason a map is drawn. This racial predominance theory comes from Shaw v. Reno case, where in North Carolina, in the early 90s, the Clinton administration, enforcing the Voting Rights Act, and under what was then Section 5 of the Act that created the pre-clearance requirement, told North Carolina, look, you have to draw an additional district to benefit African Americans in North Carolina. They drew that district in that crazy snaking way from southwestern Durham along I-85 to eastern Charlotte, sort of spanning like 100-mile arc in one political district. So that district didn't meet the sort of standard rules that you talk about. You want a contiguous and, compact district where people roughly in the same community are together, right? People in Raleigh and Durham don't necessarily have the same interest as people in Charlotte, 100 miles away. This is coming from a guy who grew up in North Carolina. So the Supreme Court takes up this, the government argues, well, the Voting Rights Act requires this. The Shaw plaintiffs basically argued that this use of race, offended the Constitution, offended the Equal Protection Clause. And the court, in an opinion by Justice O'Connor, agreed with them, right? That the shape and the lack of conformity with the other sort of standard, measures of drawing a good district was gone. The motivating factor was race. Race predominated the drawing of the map. And people have taken that in the 30 years since to basically say you can't use race too much. So current law basically says, on the one hand, under Section 2 of the Voting Rights Act, you can't draw a district against the minority. But under Shaw, you can't draw districts in a way that so benefit maybe or so target the predominant factor. And in that sense, you have these two measuring sticks around racial discrimination in voting, and legislatures should draw them in such a way that, you meet both tests.
I want to just follow up. How is that enforced? How do you prove it? Are you talking about disparate impact here, disparate effect? And
I'm not talking about disparate impact. I'm talking about what under the Voting Rights Act would be called the results test. We don't care about motive under the Voting Rights Act. We don't care about intent. And it's not strictly a disparate impact issue because we look at the one district in its entirety that is a problem. And if the result of it being drawn is that the minority group's effective voting is diminished, then it can be declared illegal under the act.
Well, then what about using party as a proxy. If, as we know to be the case in many states, there is a disproportionate number of racial minorities or particular races, let's say the African American communities, tend to overwhelmingly vote for the Democratic Party. Isn't it possible then, and possibly even common, that partisan gerrymandering can be the ruse behind racial gerrymandering and therefore then not be found to be a violation of the statute? Or how does these two types of gerrymandering interact, especially in light of now this 2019 decision where it sounds like the Supreme Court said we're not getting involved if it's partisan gerrymandering?
So, yeah, I mean, ever since Ruccio, you have litigation, especially to talk specifically about African Americans, in like South Carolina and Louisiana and Alabama, were part of the conversation by, in all three of those states, the Republican Party drawing the maps and their explanation for them when, say, a Voting Rights Act suit is brought. Well, we weren't trying to gerrymander on the basis of race. We were gerrymandering on the basis of party. And, people like Rick Hasen have, written a lot about the kind of race or party problem. I wrote about it a little bit in the wake of some decisions before Ruccio. But this sort of thing that you tease out here, that the partisan gerrymandering can be the explanation for racial gerrymandering if you're trying to talk to a federal court to say, oh, no, Your Honor, we weren't using an impermissible racial animus. It was partisan. And, you reason that forward is like, oh, if it's partisan, then we federal courts don't have anything to say about that. And therefore, it's just a partisan gerrymander. State legislature, go ahead and go about your day. Everything's okay. That's the sort of outcome that they want. And you've seen a little bit of creep in the Supreme Court's jurisprudence around racial gerrymanders. The Shaw theory. There was a case called Alexander versus the South Carolina chapter of the NAACP, where the racial gerrymandering claim was brought because some of the districts around Charleston, South Carolina, were being reconfigured, and a certain number of African Americans were moved from a Republican district to, the Jim Clyburn, who is, one of the senior Democrats in the U.S. House, I'm sorry. And so it was alleged that this was an impermissible racial gerrymander, but the Supreme Court ultimately held for South Carolina. And in part of that, Justice Alito, writing for the court, basically gave a lot of deference to the state and basically argued that there should be a consideration of good faith on the part of a legislature in its redistricting, unless there is sort of ironclad evidence of racial animus. And so even in the Shaw claim, you see this kind of softening of the race or party problem under this guise of deference to the partisan motives if there isn't a clear, evidence of racial discrimination. So the line becomes more and more blurred, and it seems the court is more and more wanting to assume that it's partisan gerrymandering as opposed to racial, unless you can prove otherwise.
Right. Or I want to ask you how this relates to a separate but related issue, which is voter suppression, right? Because there seems to be a larger divide between the parties than just redistricting. So what measures have been recently proposed that might pose risks of making it more difficult to vote, whether by racial minorities or by majorities? Because I think that, from my non-expert perspective, it appears that some of this voter suppression that at least, facially seems to be being pushed forward by members of the Republican Party could backfire on them as well. And even though, rhetorically they seem to either explicitly or implicitly admit their motive is to suppress the voters that are racial minorities or Democrats or in urban areas. And obviously that can boomerang back to them. So can you explain to us how voter suppression is related or not to these redistricting legal conversations and legal disputes?
Yeah. So I think that, the technical words that scholars give to it is that, we've been talking about vote dilution, right? One vote becomes less worth another because you're, say, concentrating a minority group. And yeah, they might get to elect one representative, but they have enough people that they could elect two. But then this sort of vote denial problem is the other half of this, right? And scholars like me see both of these as part of a system where they will sort of influence the shape of a district in one hand. And, you know, given what we've talked about, the party in control gets more and more discretion to do so. But on the other hand, they use vote suppression tactics, and to name some examples, we've been talking about voter ID for, 17, 18 years now, voter purges, where if you don't vote in several elections, you might get summarily kicked off the polls, the loss of opportunities for early voting, the ongoing debate about mail-in voting right now, where the president of the United States has explicitly said he's leading a campaign to abolish mail-in voting. The more we shrink opportunities for individuals to vote, the more we see folks might feel like they're being shut out of the process. And given that these opportunities are designed for more people to be able to participate, particularly the poor, the very young, the very old, and people of color in particular, the more they might feel shut out of the process. Probably the most prominent proposal out there these days is what's called the SAVE Act. And the SAVE Act includes provisions where people have to demonstrate, if it passes, it's currently in the House of Representatives. It may move to the US Senate, but it also reflects this policy of, wanting proof of citizenship requirements imposed in elections and wanting people to document their name as on their birth certificate, as opposed to any other time they might change it during their lives, and making more strict the opportunities in order to participate and vote. And so these kinds of proposals, I would say, end up frustrating the opportunity to vote because some of them are being implemented on the state level, along with these attacks on mail-in voting, along with, stricter voter ID laws and all of these sorts of things. It certainly creates the illusion that the folks who are most vulnerable to these things, because we can look at census rates and realize that people of color disproportionately have fewer of the qualifying IDs than the white majority, that, you look at other data around, people on the margins and their ability to participate, creating fewer opportunities to go vote during an election season, limiting it to election day might make working folks unable to participate. All of these things create this kind of perception of unwelcomeness to the political community. Making it harder to vote sends this message. And let me just add one more point, right? That this 1-2 punch sort of seems to be part of a cycle, in my view, where we've had expansion under the Voting Rights Act. We've had tremendous changes over generations. I mean, to be pointed, a lot of this turn has been around the election of Barack Obama, right? Where there was tremendous turnout, especially amongst communities of color. Before then, the Voting Rights Act was ratified with supermajorities in Congress across both parties. Like the last two reauthorizations were signed by Ronald Reagan and George W. Bush. But then you see the shift when you look at the reality of minority participation and how voting rights has become more partisanized, and you see the rise of this myth of voter fraud and all of this talk about illegitimate elections, turning a conversation from let all people vote and have equally weighted votes to voting has to be strictly managed.
Right. And I wanted to just quickly go back to the issue of gerrymandering and racial gerrymandering, because I know there was a important case before the Supreme Court this year, Louisiana v. Calais. I'm going to mispronounce it. Calais. Can you tell our audience a little bit more about kind of the key facts of that case, and then what you noticed about those arguments that are shaping current politics today, and we're in December 2025 at the moment?
Right. So as of recording today, because part of the challenge of this field is that I could get a text right now and everything will change. You know, the Supreme Court has decided this or that. So recall we talked about there are these two lines of decisions around gerrymandering. Section 2 of the Voting Rights Act, racial gerrymandering under the Equal Protection Clause, and the Shaw theory. So in Louisiana, where Speaker of the House Mike Johnson is from, very important state, it was found, to have violated Section 2 of the Voting Rights Act by not creating enough opportunities for African American representation in the way that Louisiana's congressional districts were drawn. A federal court ordered Louisiana to draw a second African American Opportunity District. The Calais plaintiffs, who claim to be non-African American Louisianans, sued, saying that that order violated the Shaw principle, right? Violated the Equal Protection Clause. And they're basically arguing that any race-conscious use of redistricting would violate Shaw. And interestingly enough, they rely largely on the Supreme Court's decisions in a completely different context, but speaking directly to race, Students for Fair Admissions versus Harvard, for the notion that any use of race should violate the Equal Protection Clause, a state's use of race. So these two tests, which were kind of seen as running in parallel, the Calais case puts them in tension. And it seems like I sat and watched all of the 2.5 hours of oral argument, and it seems like the court was looking for a way to harmonize these two cases by changing Section 2, but the conservative majority didn't seem to all stand behind one theory of this, right? So some of the justices were looking more towards, whether Section 2 is even constitutional, or at least constitutional as applied to redistricting in light of Shaw. Other justices were looking at whether Section 2, as it's currently designed or applied by the courts, exceeds Congress's power under Section 5 of the 14th Amendment in terms of the congruence and proportionality test, that Congress can only, legislate to the extent that the power of the Constitution allows it to do so. And thus, the remedy that Congress comes up with has to be proportionate to the problem that it's trying to solve, right? law professors and students recognize the city of Bernie test. Other justices, the liberal minority, right, was defending the statute as a manifestation of Congress's power under the 15th Amendment to legislate against racial discrimination in voting. And certainly there was a variety of claims. The NAACP basically was lead counsel here, arguing before the court. It pointed out that in 2023 in Allen v. Milligan, the court had given a thumbs up to Section 2 of the Voting Rights Act. And, the liberal justices were pointing out the irony of, they decided Milligan and SFFA from the same bench in the same month, and that the court itself had not seen a problem. But now there is this tension. But I would at least predict that Section 2 going forward and that jingles test will get transformed in some way when the court rules on this. Which brings up one last quick point about the 2026 election. To be clear, because there's no direct control of partisan gerrymandering, basically the only de facto control on gerrymandering generally, including what's motivating the mid-decade redistricting problem, right? The only control on it that currently exists is Section 2 of the Voting Rights Act. Because both in Texas and California, these mid-decade gerrymanders have been challenged under the Voting Rights Act. And given that, if the court very quickly changes the Voting Rights Act, then there'll be no control on the mid-decade redistricting process. And I would think that you'll see more and more of the shell game of trying to draw districts to, in this case, the Republicans were protecting their very slim majority in the U.S. House of Representatives. And so this is the way all these things are tied together. If the court waits till June, then by that point, the districts are locked in at least for 2026. So a lot is riding on this Calais decision.
Wow, that's really interesting and does show how things keep changing in this area. I want to finish this very informative conversation. We're so lucky to have your expertise to help elucidate these otherwise complicated kind of legal and political challenges we're facing. But for our kind of non-legal audience, if the developments in the law that you've described in our conversation here seem to be reversing the protections for people of color, and new statutes appear to be that are being created or passed create the potential for making it more difficult to vote, then how should we think about the state of our democracy? And is it even worth voting and participating, which we know is a constant refrain by cynics, regardless of age or the era that one is speaking in. But how does this all impact our democracy? And what part of that is new? And what part of that is a perennial challenge that we've always faced in trying to preserve our democracy?
The biggest question for the last minute of the podcast. It is a problem as old as the Republic itself, right? It is America before the Civil War, evolved from a property hierarchy to a white male racial hierarchy. There was the moment of Reconstruction, the 11 years where we had at least a multiracial democracy amongst white and black men. But then, of course, that was undone by Jim Crow. And then Jim Crow was undone by the Voting Rights Act and the recognition across American society that, using the indirect devices, the descendants of which we see in the modern day voter suppression, was unfair and undemocratic and created a moral dilemma for America. And so it feels like this cyclical life that we experience in our democracy might be repeating itself, right? And so it's fair to ask, what's the point? But I think the point is the engagement and the insistence that some of these works are unfair and un-American, and that we ought to aspire to be a democracy for all of us and not those of us in power, actually can move and change minds, and it can ultimately change the law. We have seen this time and again in American history, and therefore it is still possible. People want to abandon elections, abandon politics, but politics still matter. America's democratic legitimacy still matters, because the most cynical piece of evidence in reply is no one's actually out there stripping the vote from people. No one wants to amend the Constitution to impose the kind of removal of people. They would be seen as the hypocrites if they did that and be thrown out, I think. I think our politics still matter, and persuasion still matters, and votes still matter, because we've seen with Obama's election, for example, that notwithstanding all the devices, people power can actually change things despite the power structures. That is something that cannot be captured and destroyed while still calling ourselves a democracy. That is the advantage that we have to work on if we want democracy to flourish.
Well, I appreciate you ending this on an optimistic note, although we both know there is a lot of fighting that needs to be done within the courts and also within politics and social movements. But I do appreciate you bringing that your perspective and your expertise. And I would encourage our listeners to read the excellent scholarship of Professor Atiba Ellis and learn more about his work and also voting rights because it affects all of us. So thank you so much, Professor Ellis, for joining us today.
It's my pleasure. Thank you.
We hope you enjoyed today's episode of the Race and Rights Podcast. This podcast is hosted by the Center for Security, Race and Rights, housed at Rutgers Law School, also known as the People's Electric Law School. CSRR engages in research, education, and advocacy on issues that adversely impact the civil and human rights of America's diverse Muslim, Arab, and South Asian communities. We do so through an interfaith, cross-racial, and interdisciplinary approach. To hear additional episodes of the Race and Rights Podcast, check out our pages on Spotify, Apple Podcasts, Amazon Music, and everywhere else podcasts are available. Now, for a deep dive on these issues, visit our website at csrr.rutgers.edu, where you can find policy reports, teach-ins, and news commentary by our over 130 faculty affiliates. To watch our over 80 academic and public policy lectures, subscribe to our YouTube channel at Rutgers Center for Security, Race and Rights. And on social media, be sure to follow us on Instagram at Rutgers CSRR and on Twitter and Facebook at RUCSRR. Finally, you can financially support the Center for Security, Race and Rights by going to our website at csrr.rutgers.edu and press the donate button. And please give generously. As always, be well and see you next time.